You know what INEC did? They simply came and quoted an answer that somebody won the election against the express position of the Act. The Act said you have to compile, update, and maintain, polling unit by polling unit, all the results, and you must be ready to show it to any person or political party that demands it.
Okay, my people, still on Bola Ahmed Tinubu affirmation as the president of Nigeria. The spokesperson for Labour Party, in person of Justice Okoro, has come out to prove the incredibility of the INEC results, saying that the Supreme Court Justice Okoro attests to the non-uploading of results to the IRF portal reduce the confidence of the people in the election. Please, if you have not yet subscribed to this channel, please do stay connected, as the video will be played and you will see the facts Justice Okoro is actually driving out. Please make sure you share this video, share it to other social media platforms. Don't forget to like our video so that YouTube will recommend it for us. We will be back shortly. Welcome you back to Top Notch Gist Entertainment, where we bring you the latest happening in both Nigeria and the world at large. If you have not yet subscribed to this channel, please do well to click the subscription button and the bell icon, so that whenever we bring the latest update to you, YouTube will kindly notify you. Coming from what happened yesterday from the Supreme Court giving the judgment and affirming Bola Ahmed Tinubu as the president of Nigeria, Justice Okoro, which is the spokesperson for Labour Party, has come out and he said that the only result that they have is one presented by the INEC, that they do not have alternative presented to the court. Justice Okoro also give a big blow to the judgment made by the Supreme Court that it doesn't follow the lay-down act, which he concisely explained in this video. And he also make a claim that the electoral community never gave a distinct breakdown of the election by compiling and updating polling unit by unit, and must be ready to show the result to any political party that demands for it, and which actually shows that nothing of such ever happened. With this, it actually shows that it is the opposite that played out throughout the election period. And before all these electoral issues can be reduced in Nigeria, the position of the INEC chairman must not be based on appointment. And he even went ahead and praised Peter Obi that he's the only candidate that nobody has said anything that dented his image. Justice Okoro also said that since the court could not address all the petition brought to the court, that which makes the judgment incomplete. Just stay back, my people. Watch the video that I'm going to play, and you should give your opinion about what he said, because he actually said a lot of things in the video. We'll be right back.
Let me tell you what the Supreme Court said. That is very telling. Justice John Okoro, while delivering JSC, while delivering the judgment, he looked right to his colleagues and looked left. He said, let us admit that the non-uploading of the result on the IRF portal reduced the confidence of the people in the election.
Reduced, but didn't eliminate it.
Good. That is how the judges talk. Reduced means it wasn't as credible as it would have been if the law was obeyed, that said you should upload on the IRF portal for the people to view. And this is in line with all the decisions of the international and local observers. The only result we have is the one presented by INEC. We do not have alternative result presented to counter it. Now, let me tell you the implication of that.
Yeah.
You know what INEC did? They simply came and quoted an answer that somebody won the election against the express position of the Act. The Act said you have to compile, update, and maintain, polling unit by polling unit, all the results, and you must be ready to show it to any person or political party that demands it. And that is when you would now pronounce a winner. And I'm talking about section 62, subsection 2 and 3 of the Electoral Act. INEC did not. They just woke up one day at the dead of the night, 4:30 a.m., and declared an answer, which we did not know the formula or the statements that they arrived at to get that answer. So how can you tell the petitioners to produce polling unit by polling unit the result to prove their election, where the institution that is bestowed by the power, giving 400 billion naira to do that, failed to do it? And then you're asking, where will we get it from? The credibility of this election will forever be tarnished. And I agree with the Supreme Court that the confidence of the Nigerian people in this election was reduced. And for me, it was destroyed. Thank God, by even mentioning the paragraph 93, they have agreed that subsidiary legislation is part of our laws. Now, paragraph 93 is not even applicable to this petition at all. Paragraph 93 is in a case where there is no hard copy of Form EC8A. What you would do in a case where there is no hard copy of Form EC8A. It is not the case of the petitioners that there was no hard copy of Form EC8A. So the Supreme Court, even relying on 93, is even wrong. It does not even apply. But let me tell you what they did that brought the whole contradiction. Supreme Court was saying that uploading on IREV was not mandatory. Good. Even by the paragraph 93 they quoted. Paragraph 93 said, if Form EC8A is not there, you use the result electronically transmitted and you use the result uploaded on IREV to declare the result. So if the law does not mandate the uploading of result on IREV, where would you see it to use? This is by the paragraph 93, which they love so much, which is not applicable because it is not the paragraph that is responsible for collation. The paragraph that is responsible for collation is paragraph 48, A and B. I am surprised the Supreme Court did not even mention it at all. Let me tell you what it said. It said there shall be collation only when the collation officer confirms the veracity of the result in the beavers of the accredited voters and confirms, I'm talking about B now, of 48, of the number of votes that is transmitted electronically into the system, that if the collation officer does not have it to confirm, to verify, there shall be no collation. This is by paragraph 48AB. Meanwhile, paragraph 38, I and II said INEC must electronically transfer and transmit using beavers to the electronic system, and you do a scan copy of the result and upload it on IREV. These are two different things. Transmitting to the INEC server or whatever you call it and uploading on IREV, these are two different things stated in paragraph 38, I and II. Let me tell you something. Supreme Court talked about section 60, which talks about transfer. They did not mention anything about section 64. And section 64 is the section that deals with collation. And I'm talking about the Electoral Act. And section 64, 4AB, made it clear. The collation officer shall collect result and announce it subject to his or her verification of the manual result with the result in beavers and with, well, we have very brilliant lawyers. I respect them very passionately. They put in their best. But when it comes to
their best clearly wasn't good enough.
It was good enough. But according to the realist school of jurisprudence, whatever the judges say is the law becomes the law, irrespective of whatever you do as a lawyer.
It's a dictatorship, is it?
So, but you know, I was talking about the collation, because our problem in this country is not people going to vote. It's what happens at the collation centers. The whole idea of the electronic transmission is not about free fair. It is about credible election. It is to check the malpractice that goes on in the collation. Good. Now, you know, collations are at different levels. You have the ward level, you have the local government level, you have the state level, you have the federal government level. Do you know, INEC made provision for electronic transfer for each level. So INEC said when you finish the election at the polling unit, you transmit from the polling unit in real time using beavers, and then you will carry the form EC8A and the beavers, and I'm talking about paragraph 38 III, you carry these two to the collation center. That's the first ward center, and the collation officer must compare the two results, and I'm talking about paragraph 50V. And when they finish comparing and collating, they transmit electronically from the collation center, and I'm talking about 50XX. with which the next collation level will use to collate. And when they transmit at the local government level, when they finish, and I'm talking about paragraph 53, XII, they will still transmit electronically to guide the one in the state. And I'm talking about 54, XII, paragraphs, regulations, INEC wrote as subsidiary legislation. I'm surprised the Supreme Court did not see all this.
Well, I mean, to be fair, it sounds sort of, for the ordinary person on the street, I mean, you are obviously a legal expert. It sounds monstrously complicated, but let's go
It's straightforward.
let's go to the issues that appear to be more straightforward. For example, the issue of the Federal Capital Territory of Abuja. They adopted the position of the Election Petitions Tribunal that Abuja has no special status. What is your reaction to that?
The interpretation of the Constitution is the sole prerogative of the court.
So you agree with their interpretation then?
Whether I agree or not is not the issue. This is now the position of the law. And like I said, you can't take the power away from them. It is the power the Constitution has given to them.
Right.
They say, after reading this, this is our interpretation. Prior to this, such a situation has not arisen in practical terms in any election. This is the first time that a presidential candidate will be so unpopular that he did not win 25% in the FCT. That's why I said you may have had a constitutional government, but not a democratic one.
That's a good point.
That is their interpretation, and I respect it.
And just to confirm that, in terms of some consolation to be taken away from that judgment by the opposition parties, they did say, and you confirmed that not uploading the result electronically reduced the confidence of Nigerians.
And that implicitly means there was no credibility in it. In the eyes of the people.
It doesn't mean that there was it means that...
Can you interpret it?
Well, I don't want to get into the verbiage, but it just means that there perhaps could have been more confidence rather than less.
Well, at least what he said is there was less.
Yeah,
from your interpretation.
But it depends on how you quantify
in
less.
Society,
you see what I mean?
Professor Mahmoud
That's really
resign by that statement from the Supreme Court.
Yes, you could make that argument.
No, I have been making it, and thank God the Supreme Court has.
You could certainly make that argument.
That you did not do what you ought to have done to get the credibility of this election and make it convincing to the people. And after spending this humongous amount, my own opinion respectfully is that he should step down.
So what's the next move for the Labour Party? Is it now to look towards 2027? Because, I mean, Peter Obi still commands a very large, almost fanatical following with the obedience. I mean, clearly he's still got a political future.
So before moving to the next level, will it surprise you to hear that Supreme Court did not make any determination at all on our issue 4, which is about the forfeiture of $460,000 by the second respondent, which is Bola Tinubu.
Listening to this video, Kenneth Okoko leave no stone untouched, giving his point and also backing it up with Electoral Act, including the sections and subsections. The danger that the court is trying to avert, which is the evidence that the FBI want to tender before the court will later boom range, which nobody will be able to contain. Please drop your opinion in the comment section. Please do not forget to share, like our video, and subscribe, and also click the bell icon so that YouTube will be able to notify you. See you in our next video.